Very good afternoon, Honorable Chairperson of the session, dignitaries, organizing committee. I feel I have been honored by inviting me to be here. I am the ex-student of this department. I obtained my LLM PhD from this university. At present, I am professor and head of the department of the University of Calcutta. But whatever I am going to present here is, I will delimit myself in the light of the chairperson, just he has delivered, and certain agenda he had fixed for the session. As per the direction, I am not going to explain here is the need of the legal education and so on. However, the session is purely on the examination agenda, but I have added it in the admission. Admission and examination two are the major issues regarding the legal education. Legal education is purely befitting with the other education. Therefore, in 2020, Indian education policy has exempted legal education and medical education from the purview of the general agenda of the national education. I have the experience of working in the National Law University. I worked around 3 or 4 years in NUJ's Juridical Sciences. I worked along with Professor Menon. I worked along with Professor M.P. Singh while he was Vice Chancellor. So having the experience of the National University, which is a new model upcoming in India, rather in Asia and other parts in the world, the everywhere issue is the brilliant students are coming definitely through the entrance examinations. Once upon a time, the law has studied a different category of students, those who had either no ambition in the life or they have decided to time pass. But brilliant students are coming. Therefore, it is our moral duty to give the shape, therefore, to issue examination and admission issue. So far as the admission in the law courses are concerned, most of the universities throughout the India getting admission through the entrance examination. Therefore, assessment is there. So, examination is an assessment method. You have to cultivate or you have to decide the student inherent capability, and the best student or best merit you have to give the respect. It is the ultimate decision of the entire legal development in the world throughout. First university in the modern Asia is the University of Calcutta, established in 1857, 24th of January, as an affiliating university. That's during this time, the University of Calcutta was only the university providing the certificate, and teaching was in the college. So there is a college and university relation. The same year, 2 more universities have been established, Madras and Bombay. They are the affiliating university, and I am working in an affiliating university, not like a Banaras Hindu University, which have the national importance under the constitution. But Calcutta University and other universities not like that, having the national importance. Still, there is no any difference between the BHU having the national importance or other universities. So more than 60 years, 40 years worked the University of Calcutta, Madras and Bombay. Calcutta University had the jurisdiction right from the Rangoon up to the Agra and other universities. So after 40 years of a British administration, because 3 universities have been established in India as per the plan of the British Parliament, and the Calcutta University started functioning with the 3 branches of knowledge: law, medicine and technology. Law faculty still surviving in the University of Calcutta, but medicine and technology, they have been ousted from the university. They have their separate universities. So after 40 years of examining the functioning pattern of the university, a commission has been set up, and today it is the high time to re-examine the report of the committee to solve the situation, emerging situation of the examination and admission. British people they have established the university and colleges separately. Then during in Calcutta University had only provided the degree, that is degree providing university, and teaching faculty was in the college. So then there is a college and university relation. So first report is the 1992 report, Indian Universities Commission Reform in the Examination. I think today all of we have to rethink what are the 15 principles they have developed and whether we can get anything from this. And I find all the 15 principles are still relevant. We are just ignoring for one issue to other issue. We are not adjusting anything. We are rather diluting our workload from this ground or that ground. In NUJs, what are the model of examination had, I will discuss, and what I am doing here in the Calcutta University at present, I will discuss. And I find that our system, which is mostly based on the 15 principles of the Indian 1902 Indian University Commission and Reform. Why I am giving more emphasis? Because this report is called Shimla Report. And relying on the Shimla Report of the 15 principles, one act has been enacted by the British Parliament, is Indian Universities Act 1904. So if we like seriously to solve the problem, we have to first respect to the Constitution of India, that is equality before law and equal protection of laws. So our degree, whenever it is given by the Faculty of Law, Banaras Hindu University, and one degree is given from the Department of Law, University of Calcutta, there is no any difference between the market value. Only is that geographically it is situated in Banaras, another is geographically situated in Calcutta. So student in the Calcutta, not only studying from the Calcutta geography, even from Banaras, my students are there. And after getting their studies, LLB studies, I am recommending them for London University. They are getting admission on my recommendation, on a pad, on single writing in a pad in the department of. So what are the 15 principles? First principle of need for the examination. Why we are taking examination? It is an evaluation process, and we have to understand the inherent capability of this very boy or girl, right? And as a result of which we are giving the certificate, and his or her certificate is giving the respect throughout the world. If a student getting admission BLLB honors or BLL from the University directly can be an advocate in the America, because equivalency is there. But very few universities there directly can be advocate in America, because there is another method of equivalency system. So our law degree is almost equivalent throughout India, I believe, because all of us are duty bound to respect the syllabus or curriculum established over the time by the Bar Council of India. So in this way, to some similarities there. At least there are certain subjects that are compulsory, have to be taught in LLB level, and this subject, without this subject, LLB degree is not being approved by the or affiliated by the Bar Council of India. Although it is a different question whether how they have acquired the power, whether Advocates Act is justified or not. I find advocate is not justified, and I find there is legal education. It is a wrongly drafted the Constitution of India, because legal education is given under entry 25 and 26 of the 7th schedule of the Constitution of India. Unfortunately, I will read before you will don't believe that you see in entry 25 the word education is there. Education including technical education, medical education, universities. Entry 25. Entry 26 legal, medical and other professions. So legal is the profession, not the education, but medical is the education. So Constitution don't believe that is there can be possible that legal education. It is a wrong drafting, or it is a missing point of the growth and development of the examination and education system of law. I think it is immediately required to be reformed first, then we can think about the examination system. It is unfortunate part. How Bar Council of India acquired the power? Indian Advocates Act given their responsibility to look into that is behavioral pattern of the advocates. And one word is there, they will look into the legal education. And relying on this, they frame the power, they frame the rules. Because another word is there, missing point. In consultation is the university. How many consultations they did with Calcutta University? How many consultations Bar Council of India obtained from Banaras Hindu University? No. It is one-sided. Certain rule has been framed in a situation, fortunate situation of the Bar Council of India. What infrastructure they have to look into so disaster, so beautiful education system? It is unfortunate development in the legal education. So first we have to justify why we are taking the examination for providing the degree. I can ask how my teacher has given me certain marks. Yes. So second is general scheme of examination. So you have to develop certain examination pattern. So sir has pointed out certain points. That is fairness. So I will put the example of the University of Calcutta. As a result of these Indian Universities Reform Commission report, that is act has been enacted during this time, and entire power has been given to the syndicate in here this university EC. So and regulation making power has been vested on the universities under there. So under the regulation 1 BOS, Board of Studies are there. Board of Studies in my university chaired by the head of the department. So all the affiliating college and the full-time teachers are the member of the Board of Studies, and they recommend the name of the paper setter moderator. After that, it will be placed before the controller. Controller will get the permission from the Vice Chancellor. Vice Chancellor has certain power under Section 6 of the Act and 9 Act. And under exercising the power, this process is continued. So after that, evaluation. So in my university, how evaluation is taking place? After examination, all the copies, answer script are brought into, and after that, coding process is there. No rule number can be given, is possible to be disclosed. Coding, after coding, all the questions, paper, answer scripts is that is concentrated in the Centenary building 9th floor. And after that, the confidential list of the teachers will be given to them, and they will evaluate only, right? And after that, there are scrutiny, there are second examiner system. If there is a marks between 15% marks variation from the first examiner and second examiner, then third examiner will be given in master degree. But in bachelor degree, the scrutiny is there. After that, most of the time, cases are going to the court. We have to place the answer script before the court. So this method is there. So in NUJS method is there, because it's a small university, single department university having the 100 students. My student strength is first semester 2,000, and 10 semesters are there. So that is there are 5-year course, so 10,000 students. In NUJS 100 students. So they can easily manage everything. But for me, and Calcutta University is not the single case. Similar large number of affiliating universities are there in India, having the same issues. So second, so in this way, the examination that is controlling check confidentially, and that is quality is maintained. So our syllabus in my Calcutta University syllabus, every subject, master degree and bachelor degree both, 5 years LLB, and subject is divided into 2 parts. One is 20 marks for internal assessment. The teacher who is teaching only can evaluate. How many time I have?
10 to 12 minutes.
Achha.
We have 6 speakers. So
no, हमारा कितना बाकी है भैया?
time is exhausted, already exhausted.
So in this way, my only submission here is that we have to rethink about the 1902 University Commission reform, because all the report I have studied submitted to the Government of India, never they have consulted, never they have considered the affiliating university. What will happen for the affiliating university? Thank you very much for listening me.